Welcome back. This is occupier Kaylin. The board members and the attorneys will be taking their seats along with their direct staff. The deliberation will continue with a couple other issue sets before they close it out for today. They took a break. Probably some staff are retrieving some documents that the board members and or the attorneys may have requested that they didn't already have, or just to stretch their legs and take care of the personal business. So again, the way it looks now, there will not be a decision today. So the next Friday they will meet in closed session with the attorneys to discuss some matters relating to documents and other things that cannot be discussed in open session. Then on March 8th and possibly 9, they have reserved both dates for final days of deliberation, and at the end of which they may render their decision, or they may choose to wait for another day to actually render their decision. But I will be back here for both of those days if they take both of those days, March 8th and 9th, and they would begin at 1 o'clock, I'm assuming. Since that's when these open sessions have been taking places at 1 p.m. Central.
Oh, that was.
So I will be here for those. And then if they do render a decision, I will have that for you live. There has already been some shady stuff going on. You know, like the one guy who was offered the services of a prostitute.
I know, what was up with that?
Yeah, that's whacked.
Yeah. That's just one thing that we found out about.
Yeah. Yeah, and the fact, and there's been stuff going about how the oil will not go up to the Minnesota refinery. It would go straight down to New Orleans to be refined specifically for export. And that was even talked about before the export ban was lifted. So that's been out there.
Our Utilities Board is now in session. I'm going to turn to Mr. Wright to provide a little bit of information related to our 8 items that we went through that have been pulled out of Exhibit F.
Okay, when a company such as Dakota Access files a petition, the board's rules lay out various exhibits which contains information about the proposed project that is needed to be filed. And one of those with regard to hazardous liquid pipelines is Exhibit F, which the board has been discussing today. And that is where the company here, Dakota Access, lays out what it considers the factors that go into the determination of meeting the statutory requirement of promotes the public convenience and necessity. And I think if you pull that up, you can access that on through the board's electronic filing system. It doesn't have necessarily 8 factors, 8 paragraphs numbered the way you've discussed them, but it does have 8 factors as you've discussed. So it's more of a narrative in Exhibit F. And I think you can see it now that it's being pulled up on as in showing on the screen.
When we get to the conditions and identification of those for next Friday, I think that it might be helpful if we identify where that condition was pulled out of. If there's multiple, I don't care, but if it's in one or more reply briefs, just state that. Can you do that?
We should be able to do that, yes.
That way we won't have people having questions about where are we pulling the information from. We've at least identified somewhere within the petition or the transcripts that information is obtained. Thank you. Do you have anything further to add?
Well, I just would point out that when we have discussions later on about the agricultural mitigation plan or the damages, those are additional exhibits that are filed with that petition. So if somebody wanted to kind of see it, get an overview of the project and the proposal, I mean, that would be the place to go. That's the initial filing that contains what is required by the board's rules to begin the whole process.
And if I don't remember, just remind me to refer back to it when I'm talking about it or presenting that for a topic.
Okay.
All right. For those of you that have been in attendance or listening or viewing over the last 4 days, day 1 included conversations on the law as it related to items that we required be set out in the briefs that were filed. On Monday, we provided an outline of issues for deliberations, and I believe our technology bureau has that outline available. We are going to be starting and going through the list for board discussion on the items that are set out, beginning with B on global issues. And although we've touched on some of these items during our conversation on the petition, there are also others that we may add to this item as we get there. So the first issue that is going to be open for board discussion is on global issues and climate change. Mr. Wagner.
Well, I believe this is where you said the other day that we would disagree. I don't know that we do that much. When it comes to the merits of the case, let's say it that way. Because I don't think whether or not we believe that it does or doesn't exist or is or isn't caused by the consumption of fossil fuels. I don't know that weighs in this case, because again, I go back to the consumption is driven by demand, and I don't think that a pipeline changes the demand all that much, and therefore it doesn't change production all that much. So I don't know if we need to get into the merits of whether or not we do or don't believe it is occurring, or is man-made, or it's caused by fossil fuels or anything else. I think, like I said, the fact that the use of fossil fuels and the use of oil is driven by demand is the overall is a major factor from my perspective. And we've talked about, I've already explained how I don't think the pipeline changes significantly the demand or production.
Are you implying that you'd be willing to include in a board order that global climate change is a critical concern and it is something that should be addressed?
I think for some people it is a critical concern, and some people
do. Yes?
And some people do believe it should be addressed.
Because that's
you're trying to make it so I can never run for office again, which my wife would appreciate.
I actually think that would be a benefit for somebody running for office, but there's where our differences would begin. And I think that you're on point with the weight that's to be given to this issue on a pipeline, and I know that's where I believe this is a critical issue, but we have to follow the law, and the law says you weigh this against the other items that are before us. So as long as you're willing to admit that it is a critical concern, and we can put that into any order that comes out, I think we're on the same page, Mr. Wagner.
Well, I believe you would have to get at least 2 members of the board to agree to have something like that in it. So I may not be your only hope, is what I'm saying.
Well, since Mr. Wagner won't commit totally here, I do think obviously climate change is a global concern, and I agree with Board Member Wagner, whether it's man-made, whether it's fossil fuel, whether it's cyclical in just the history of the earth, and this is things that just come together in more of a perfect storm. I do think it's certainly a significant issue, but I think relative to the merits of this case, as both of you have said, it really comes back to production and demand and the role of fossil fuels, and I'm not convinced that climate change, the merits of this case, gets the heavy weighting that some of the other issues would. So I think if you would like to put something in the order that talks about, we acknowledge that climate change is a global concern, I certainly can support that kind of language.
And if it gets too far down the path, I can always write a dissent.
So then the second part of that is the weight that we give to, the issue, but I think the direction, if it's not clear, the direction is provide us with, the background and information on that issue, and then, do you have a comment?
What we'll do is we will present the two positions as presented by the parties. And then the weighing, I think the board can do when they start to write their final analysis and make their final decision about how much weight they take into account for that issue in the overall determination of public convenience and necessity.
Okay. The second item under global issues is world petroleum market, and I know we've talked about it briefly, or we've had discussions about this, or is there any further comments from the board?
I don't have a whole lot more to add to the conversation we had earlier. I think once again, to look at the merits of the case and the weight, this probably isn't as significant as some of the other issues that would be more critical for public use and public convenience and necessity.
I'm interested in, comment was made by Sierra Club about that there's no assurance that the oil will remain in the country. Can we talk about that again?
Yeah, certainly. I think, as this case unfolded, the U.S. policy still had in place the ban on crude oil exports. The timing of Congress lifting that ban was immediately after our last hearing in Boone, I believe, within a week. It was somewhere between the end of the hearing and a week of Christmas, I think is where I want to put it. So, in terms of that, I think no one quite knows what the repercussions of that congressional action will be, but looking at the testimony from Dakota Access, it was indicated that there was enough demand in the United States for the product to be used in refineries in the United States, that was going to be the number one focus for this product, for it to be transported to the Patoka, Illinois hub. If this pipeline all of a sudden turns out to be something that is to be exported elsewhere, there's not been a lot of evidence in the case that showed that's how it's going to be used. Does it free up other crude oil to be used for exports? I guess that could be the second question. So this product would stay in the U.S., thus allowing others. We don't really have any evidence. No one talked about that. I'm not sure how we parlay that into a conversation about the impact on the world markets.
Whether or not it's used for domestic consumption, whether that's a factor, it would only be in the weight that we give to that.
At least for my way of thinking, that's how I would look at it.
I would agree, and I would probably give it a lower weight as well, from the standpoint that if you're going to look at what is the direct benefit may be that you have lower oil prices because we're producing it domestically, or because we're impacting the world market with this oil. But again, those aren't factors that I think we can look at, because we're not determining how this oil is used. We're determining if the shipping method, putting a pipeline through, is that a public necessity and convenience. The one other thing I would point out is just on the world markets, this conversation is there was some discussion, I believe, by Sierra Club and other interveners that the price of oil is decreasing, which has an impact on whether or not this project is moving. And again, I think the price has an impact more on demand than it does on whether or not this project is the things we have to look at, make a decision on the project.
Are there other issues that fall under, global, that were brought up in any of the other briefs, reply briefs, or transcripts that either of the board members want to discuss? I think that if we, as we continue to try and define conditions, exceptions, those types of things, that we may come back to other issues in each category, but I'm gonna move on. Under national issues, we've had conversations on energy independence, energy security, the difference, the arguments that have been made. Is there any additional comments on those two categories as they relate to the petition? Rail transportation versus pipelines. One of the issues under national that was brought up was both the price of oil today and the declining price or demand of oil. Both were arguments that were used by Sierra Club, I think, in showing the negatives. Or, that's what I was doing. I'm not figuring that correctly.
Are you referring to the production declines? The
The
depletion in production? Well, depletion of oil and decrease.
Let's start with price of oil.
I do believe that it was Sierra Club that, and several other interviewers who did discuss the declining price of oil and the impact it would have on production out of the Bakken fields, and that would that could potentially reduce the demand for that oil, and thus would make some economic decisions by pipelines that it would be economically unfeasible to continue to support a new pipeline project. On the other hand, it was argued that the production levels are still at a reasonable level, in some cases, I think in some historic highs, and that that really just is not a long-term factor in terms of making a case for the construction of this pipeline. I think we saw indications on both sides that we're talking about what the impact of lower price could potentially do, as well as a lower demand or lower ability for production of the Bakken oil fields. I think we saw a combination of sides on that issue. Certainly we've seen some economic impacts for some organizations that are involved with the production of oil in these fields. We also have to keep in mind that, I don't want to get into the confidential information either, regarding the contracts that have been signed for by the shippers who would be using this pipeline. Those contracts indicate that there is interest in this project going forward, and that does not seem, at least during the timing of this case, to be impacted by a declining price in oil. But I do think we need to weigh what the economic realities of today are versus even when the case was first brought before us in terms of the lower cost, the impact for a company to make a reasonable profit. I think those are issues that are certainly something we need to weigh in our decision overall.
I agree with Board Member Jacobs, and particularly for me, I was just trying to find whether or not that was confidential or not on the types of contracts and what they have. And I think that those contracts are in place again, I think I mentioned it previously, I think that shows that they're not depending on what the price of oil is doing, to ship. Because they're planning on shipping oil, one way or another. And again, I don't know that it's for us to determine whether or not, someone's gone through the FERC process of getting those contracts. I don't think it's for us to say, well, they shouldn't be getting any more. They really didn't mean to sign those contracts. They really didn't mean they're going to ship that oil. I mean, the fact that they're signed and they have them, I think shows that the price of oil right now is having little impact on their decisions from a shipping standpoint. But again, I think it goes back to demand and production. Obviously, the price is going to have an impact on those. But that's not, I don't think, in the merits of the case. And I would also point out, prices change, and we don't know what's going to happen in the future. And I think when you look at the evidence that even though Sierra Club probably didn't intend it for this purpose, it does show that there are high peaks of production and a need for transporting oil. There was no evidence that shows that because it's declining, that it's going to remain in decline forever.
Are there any other issues that were brought up that either one of you want to speak on before I move to completion? Well, we kind of talked about that. National alternatives to crude oil pipelines. Any comments you want to make on that?
On alternatives? Oh, sure. Yeah, and I think that there were several interveners that alluded to we should be focusing on different forms of energy, alternative energy, getting away from fossil fuels, and I think particularly here in Iowa, you're seeing that. Depending on whether you're looking at the amount of the capacity installed wind or the percentage of energy coming from wind, we're one or two in the state or in the nation. So I think those alternatives continue to move forward. And I don't know, again, that goes to the demand side of and using oil, where I would view alternatives to the pipeline not as not shipping the product in the pipeline, an alternative to actually using the pipeline, which the only alternative would be other transportation methods. So you're looking at rail and truck, and we previously discussed what we think about those.
I don't have a lot more to add on that. I agree that Sierra Club did point out that the growth of solar and wind energy, along with other types of renewables, could potentially offset the need for this the oil in the future. But at this point, it goes back to demand. If there's a demand for the crude oil, that's certainly something that needs to be taken into consideration. We're looking at national alternatives to crude oil pipelines. Once again, if it's an alternative pipeline, I agree with Board Member Wagner. It's a conversation also around rail and truck. But we certainly don't want to diminish the importance of renewables, particularly wind in the state of Iowa and the growing solar industry. And there definitely are some offsets, but whether it's a one-to-one offset of what the demand would be, I think is probably a little premature.
any other issues? Otherwise, I'm going to move on to permits and authorizations. Well, I'm gonna divide permits in, I wanna talk first about whether or not it is my understanding that the current process used by IUB on any project is that we put the requirement into an order that says that it is subject to obtaining permits and authorizations that are required from other entities. If legal counsel could tell me, has there ever been an instance where that's not the language or terminology we used in an order?
Not that we can remember.
And would there be a reason to do it now?
I think the decision would have to be up to the board whether there was a particular permit or authorization that they thought was so significant with regards to the evidence and to the pipeline itself that they thought they need to have in hand before they issued the order to require that.
But wouldn't that be a condition of that particular permit versus whether we require them to have the permit before they can begin? I mean, I see that as a separate issue.
Well, it could, it really is a given, I think, condition of granting a permit that they get their other permits and authorizations before they begin construction. And Dakota Access has actually acknowledged that that's one of the commitments they've made, that they will do that before they begin construction. I guess, what you're really asking is, should we require that before they get the permit? And as I think, to our knowledge, that hasn't been done before. So, I mean, I guess it's possible to make that a condition, but we just don't have any precedent for what type of permit would be that's significant in the eyes of the board.
And also that leads into another question, and really beyond our jurisdiction, but we don't know what some of those permitting processes are, the other entities, whether or not they're looking to the IUB first. As I said a couple of days ago, we're talking about a chicken and egg thing here, who's supposed to move first, or are we all supposed to move together at the same time, or if there's an expectation somebody who does something, I mean, to the best of your knowledge, no precedent that somebody else has to move first, or?
I think there is even some testimony to that effect that some of those other agencies are really waiting on the board before they take that final step and make that final evaluation or issue the permit. And I don't know that it was very specific about which agencies, but I think there was testimony that that's kind of a normal process in a lot of these pipeline cases where the other agencies wait, because if the board were hypothetically to deny the permit, then that other agency wouldn't have to take that to finish their action, wouldn't have to complete the review and issue the permit.
No, I believe, I mean, I don't remember what day it was, but when we discussed this previously, I had the same concern, how we, and I can't remember if it was Mr. Lynch or Mr. Wright, or one of them satisfied for me the language that we would put in there so that it wasn't sort of this, everybody standing there waiting for someone to say go. And I can't remember what that language was, hopefully one of them does.
Therefore, when we get to permits and authorizations, and should that be a necessity to have the language in there, I understand that with different state agency permits and authorizations, they have their own protocol that they're going through and determining whether or not their permits should be issued. some of the conditions that we're going to be talking about next week include verification of compliance with some of the additional, and the bats come to mind every time. So you don't take roosting trees out unless it's winter. Where would those type of conditions be addressed?
If you wanna use the bats as a hypothetical.
I can't think of a better example right now.
And I think if the board were to determine that the bats should be a condition, not disturbing the bats during roosting should be an issue or a condition, then that would go as a condition on the permit. If that affected some other agency's decision on whether to grant a permit, I mean, that, they would take that into account, but I think that at least that, it may not be a good example, but that example I think is really based on what the board, how the board weighs that issue as far as you put that as a condition on when construction can occur, assuming that the board were to grant the permit.
All right, and then, as you know, Mr. Wright, I've struggled with the Corps of Engineers, their permit, the state archaeologists, the Historical Society, all of these different federal and state agencies, and the coordination and communication between them. So Sierra Club has made a number of arguments that there's not sufficient information that's been provided to different entities. We've had state agencies that have testified. How do we talk about that issue and what options are available?
And Mr. Lynch may want to add to this, but I don't know that the board can go behind those agencies' process and decision making. I mean, I think what the board can have a condition, which I said if Dakota Access agreed to have the necessary permits and authorizations prior to beginning construction, but I don't know that the board can go in behind those decisions and create conditions that have to do with how those agencies comply with their statutory requirements.
And if we find that there is major revisions from any of these permitting organizations that would require the board to again look at the route or rerouting, what happens then?
In that event, let's use the Corps of Engineers as an example. If the Corps of Engineers ultimately issued a permit after the board had acted, and that permit required that a significant part of the line be relocated, then Dakota Access would have to come back to the board for an amendment to the permit that was issued.
So eventually, everything would have to be harmonized, except for that's what you're.
That's a good way to say it.
I have a question, I'm not sure how to ask it. Don't believe it has to do with anything confidential in nature, so we'll go from there. We've talked about the authority of the Iowa Utilities Board to allow conditions or set out anything that we see is necessary should we approve any pipeline. Is there authorization, in your opinion, that allows us to condition a permit granting on meeting, or that we don't believe that it meets PCN if A, B, C, and D?
Yes, I believe the language of the statute is, sufficiently broad to allow the board to impose conditions like that.
Yeah, I would agree. If you look at 479B9, permit shall not be granted to a pipeline company unless the board determines that the proposed services, oops, I'm sorry, wrong sentence. Board may grant a permit in whole or in part upon terms, conditions, and restrictions as to location and route as it determines to be just and proper. So I would read that, and I come to the same conclusion. And the attorney sitting there thinks, yeah, I need an engineer to tell me I'm right about the law.
That and realtors. Bet I hear about that one.
I appreciate the support anywhere I can get it.
Are there any other items under permits and authorizations? And again, as part of the conditions that you're going through in all of these briefs and reply briefs, you'll be setting out for us if they relate to a permit, so that we can, it's easily.
Yeah, I think part of that, we will look at the permits and authorizations that have been identified, and along with Dakota Access's commitment to have all those permits and authorizations prior to construction. I think we'll lay those out so that you'll see what has been identified by the witnesses, or which of those permits and authorizations are required as identified by the witnesses in the evidence.
Okay. Next item.
Well, just
Go
one
ahead.
second. So I don't know if these are necessarily, this would be more, I think, along the lines of, I don't think they're permits, but for example, the, I'm trying to remember what this stands for, SWPPP, stormwater, maybe that is a permit. Yeah, that is a permit. The integrity management plan, which is required to be submitted to PHMSA, will, what you mentioned that you're going to provide would include things like that. They're not necessarily permits, but they're maybe plans or things that are required to be submitted to other entities.
And we can also, if the board wants that, we will add that to the list as far as what Dakota Access is required to provide to PHMSA, or any other reports or studies that they have to complete for another agency.
And I just jotted, as we went through the hearing, I jotted down, and as I read through testimony and briefs, I jotted those things down just to keep track of them, and I don't recall if in briefs, if they've committed to providing those to the board. I know during the hearing there was some of them where they said, yes, we will provide that to the board. So I guess along with that list is those things that have already been committed to being provided and when they will be provided.
I think if you look at the Dakota Access reply brief, they list that stormwater prevention plan and another plan that they say they will provide to the board in final form.
Okay.
And then they also commit to letting the board know when they have filed the PHMSA report with PHMSA.
Okay. And I think if I remember correctly, one of those permits to PHMSA contained confidential information, and that was sort of the issue is, if the board wanted it, we would have to go through PHMSA to get it.
I think that's correct. I think that's why they only committed to letting us know when they filed that with PHMSA, but they didn't commit to actually file that with the board.
Have we ever, in the past, has the board asked for those the documents that go to PHMSA?
Okay, and we don't have a lot of hazardous liquid pipeline cases, so I don't think so with regard to hazardous liquid pipeline cases. But in, where we have natural gas pipelines, because we have a contract, we act as an agent for
Right.
PHMSA, we do receive those and are able to look at
Right.
them for natural gas pipelines.
So if we're not an agent for hazardous pipelines, will we be able to get them? Or is there some gentleman's agreement or customary, because we are an agent on one side, they give us some leeway on the other?
You know, that's something we would have to contact PHMSA and determine what their policy is with regard to releasing those kind of, documents to states that are not, have not contracted with them to become agents for safety inspection.
And to clarify, we've not become a agent for hazardous liquid pipelines because in the past, PHMSA said we didn't have enough hazardous liquid pipelines for them to go through that process of approval, because it's a lengthy, as I remember, I think it was Ms. Gerard testified, it's a pretty lengthy process to go through to get.
Yeah, and I think, you know, it's been a while, and I think initially that was kind of the determination, and I think it just was never looked into significantly after that because of the limited mileage of hazardous liquid pipeline.
We have arguments saying in testimony that states you need to do A, B, C, and D. We have Dakota Access responding back saying even the witness is testifying that A, B, C, and D are covered by this permitting requirement. We then have the response that, well, even though it's covered, we still believe this is necessary to protect certain species, protect the environment, et cetera, et cetera. Again, you believe that that provision of the code allows us to set conditions specific that go beyond those permits.
That's probably going to be a kind of a case-by-case determination depending on the specifics of how far you want to go. I think Mr. Wright has raised a good point that certainly you can put a condition on that requires Dakota Access to do something, whether it's in addition to or beyond a permit. But if at some point those requirements begin to interfere with the other agency's permit or require some inconsistent action or interfere with that agency's process, then we may have a need to work out a different way to get at that.
So it's all about semantics wording.
And the specifics of what the condition is.
And what I would say is you would want to have evidence in the record that supported whatever decision or condition you want to put on too. I think the evidence, you know, may lead you in a certain direction or not, as well as what Mr. Lynch has indicated.
Well, and that kind of goes back to some of those conditions or exceptions that have been proposed in wanting to have a list, because I think there's as we've talked about, there's one brief in here, there are no sites. I mean, we can't find where that was at in the testimony to even try and include it into the record. It's not in the record. If it is, we don't know where it is. Okay. won't say I won't do it again, but I'll try not to go back up to permits and authorizations. We are on state issues, and neither of you have any other comments on economic issues, right? Or do you? Environmental issues. Mr. Wright or Mr. Lynch, as you know, we've received a number of objections, a number of requests, a number of individuals that have repeatedly said, Iowa Utilities Board conduct an environmental study. Does the law require an environmental study?
No, the Iowa statutes do not require an environmental impact statement or an environmental assessment. They set out that the board can consider environmental issues in connection with the board in an effort to protect the environment, but it is not required the study or the assessment.
And as the three of us have knowledge, that would then be required to be passed by the legislature for it to be a requirement of that petition.
Yes, if it was going to be listed as one of the petition requirements like the others in the statute, it would have to be amended by the legislature.
So setting aside whether or not an environmental study is required by law, and moving to the other issues associated with our environment, do either of you have any questions or comments?
Sure, I'll start on that. I think there was a considerable amount of testimony on the issue of the environmental impact and the environmental attributes of going forward or not going forward with this project. There was a lot of back and forth between parties. I looked at the Mr. Toms, I believe, not Tomes, I believe it's Toms, the OCA's expert witness, who provided a variety of suggestions of what could potentially be conditions, and I would hope that Mr. Lynch and Mr. Wright, those suggestions could be included in that conditions list that you'll be putting together for us to look at. Then on the flip side, Dakota Access indicated that some of those were not necessary. I believe Ms. Howard covered in great detail the efforts from the environmental side, whether it's the agencies they've worked with, both at the federal level and the state level, whether what they were putting in the AMP, what additional things we could require in terms of land restoration. There were a lot of issues that were covered by both sides during the hearings and then in post-hearing reply briefs. So I think for us, this is certainly one of the larger issues, at least in my mind, in waiting, that we certainly have to look at. I am looking at all the different conditions, as well as, and it goes back to the conversation with permitting and authorization. What is it that we can do? What is it that other agencies do? I think trying to weigh those will be very important for us to consider. And are there conditions that we can put on, or are there things that we can require of Dakota Access that either we have thought that importance for others have brought up as important as well? I think that we could spend a long time talking about the merits or discussing things that we didn't think were so meritorious, but I think that will weigh heavily in our discussions going forward.
I would agree, and I would just make sure we add to the list. I believe it was in Mr. Murray's brief. I know it's the exhibits to his brief. He's got conditions that are both changes he thinks need to be made to both easements and the agriculture impact mitigation.
Correct, and And then as Board Member Jacobs mentioned, if you go to Code Access Witness Howard's testimony, that there's a chart which lays out some of the OCA witnesses' proposal conditions and Dakota Access's response. And so there are some, as Northwest Iowa Landowners Association laid out, there are some places in the record that really lay out those kind of issues so that you can go one at a time and consider them.
So I don't know if I started by saying, making sure those are in that list, but that's, yeah.
When are you gonna have that list for the board to look at prior to the Friday meeting?
My plan is to give you whatever the current draft is of that list, Monday morning, so that I can make sure that I'm doing it the way you want it to see it, and including all the pieces that you want. It may not, by then we may not have been able to comb through the entire transcript, all the briefs, all the pre-filed testimony to find everything, but we will continue to add to it then if it's in the appropriate format.
I think environmental issue is gonna come up again when we get into those conditions, so I'm gonna move on and pass that. On safety issues, are there any comments the board or discussion the board wants to have on remediation? Or you want me to start one? My opinion is that even though we've had assurances on the stand from testimony for the parent companies going to step in, I think there's some issues with whether or not there needs to be additional criteria set about. I know that in both the OCA and Northwest Post hearing briefs, they've talked about some of those things which were confidential in nature, so I'm not gonna go into them, but that all costs and damages, whether they're conditionally guaranteed by the parent company, I don't disagree with any of those comments. And I want to make sure that if we do move forward, that we know what exactly has to be required and whether Iowa law allows us to require that as a condition or part of the PCN to meet that element of the statute. I don't know if either of you agree or disagree with me, but
I'm trying to figure out exactly what you said. You were saying that when you said you didn't disagree with that, you didn't disagree with the statement that
OCA's, yeah, right.
That the parent does have responsibility in the event of a spill.
Mr. Mahmood testified to the fact that he said yes, the parent company would be liable for cleanup in a situation where the other funds that are available wouldn't come in above and beyond the $250,000 requirement that we have in statute. What I'm saying is, if he's willing to agree to that on the stand, if we determine that you meet the PCN, I think that the only way that you would be able to show meeting that element of the law is if they provide those unconditional guarantees along with the contracts stating the same. And it's in OCA's brief, page 18.
So I'm trying to remember if, I just did a quick search through 3,500 pages of testimony. There's too many, golf shows up way too many times, way more than I thought it would. Because I was trying to remember if there was a discussion with Mr. Mahmood at one point about the Deepwater Horizon spill, and I think, and I, do either of you recall that? And then he was saying that spill did flow up to the parent, and that's effectively how that was taken care of.
Even though the entity that owned it was an LLC,
Yeah.
is that what you're?
Yeah.
That's my recollection.
Yeah, like I said, I can't remember if that. Maybe it wasn't.
And
But I also agree that in any event, I think you wanna make sure that that responsibility does exist.
And the concern that I have with it being an LLC is it relates to that corporate structure and all of their asset holdings is whether or not the state of Iowa or landowners would have the authority to go beyond that LLC to obtain the funds from those corporate parent companies without any formal agreement. Non-revocable guarantees, I believe, is what OCA presented.
Yeah. And you would want that in addition to in the briefs, Dakota Access has indicated they will provide a $25 million policy or assurance or whatever you want to call it.
Are you gonna get your dollar back?
No, because I already told you I'm not worried about it, but I guarantee you, if we ran the pipeline and there's a spill, we'll be worried about it. But point well taken.
Do you or have you ever done any brief on the authority, on LLC authority to go after parent company for a spill in the state of Iowa under Iowa law? I know that, yeah. I think there's enough information on both sides of that to put something together, and that will probably be on your list of conditions. I think with the environmental, safety, oil spill, all three of those categories will come back up next Friday. Is there anything additional any of the board members like to say? Otherwise, I'm gonna move to cultural issues. All right, are there any issues or discussion on cultural?
There was plenty of conversation with the state archaeologist, and I think Sierra Club, concerns that the archaeologists hadn't been utilized to maybe a greater extent. But it appeared that the outside consultant that Dakota Access used conducted an archaeological survey. I believe that at least what's required from the archaeological standpoint was covered by that consultant. I think the question is, did the state archaeologist, as he was talking, because obviously maybe there wasn't some coordination between the state agencies as maybe directed by statute or as others had hoped, but it appears that Dakota Access in its testimony indicated that all of the proper all the proper investigations and the reports, have been conducted. I understand there are significant sites out, particularly, Indian burial grounds, very special areas, that certainly want the pipeline to avoid. So I think, that's been there, whether the process using the state archaeological is, late in the day, you know what I'm talking about. And, maybe their approach would have been different, but the consultant apparently hired by Dakota Access seemed to, do everything that was appropriate in terms of review and providing a report. I believe that report was in that chart of Ms. Howard's. I think was where that was.
A quick glance through the rules and the code, I didn't see what level of that type of analysis was required by the code or our rules.
I think probably the main review is by those agencies that have to grant permits or authorizations to show that, Dakota Access has done the proper review and is avoiding those, locations that were environmentally or culturally sensitive. I don't know if there's anything in 479B that specifically addresses, cultural issues.
Mr. Lynch, so if you have hindsight thoughts, is it better to wait till after you're done with the docket to bring it up?
I'm sorry to bring up. I'm not with
Do you wanna? Response is yes, it is better to wait.
Always better to wait.
I think the struggle I have with the cultural issues is, I think somebody needed to be the lead on making sure that all these different organizations came together. And there's a belief that as a quasi-judicial organization, that we're the ones to do that, and we're not. It's the testimony being presented that has to prove whether or not one thing or another has happened. And so the struggle is trying to educate individuals, including myself, on that that's not the role of the board. The role of the board is we get the testimony and evidence, and we have to take that and make a decision as to whether or not it complies with the law. And when there's briefs, for example, that are filed that have no substantiation in any testimony or records, you know, yeah, it looks really nice, but you never brought it forward until the bell already rang. So, it's a struggle. I don't like that part of this process. So how are you gonna fix that?
Well, I think, it's inherent in the quasi-judicial nature of the agency, and, the legislature has created these types of agencies, and the board, is a creature of the legislature, and you have the authority granted you by the legislature and the requirements put into the statute. And if that creates a certain tension especially with regard to contested cases, that's, to put it bluntly, that's really what the board is for, is to make those decisions. And as you indicated, really you have to rely upon the evidence that is presented before you in making those decisions. And as you're probably aware, in private litigation, sometimes that evidence does not reach all of the various aspects of an issue that you would like it to.
So, this has, been a long day. And I'm trying to decide whether to go into eminent domain and route type of conversations. Do you have a recommendation or?
I think those type of issues would be more beneficial to discuss those when we get to conditions. And I really think, as you indicated, it's been a long day. I think the discussion you've had, addresses those issues which are primarily concerned with overall public convenience and necessity, but there are route issues and the eminent domain issues which figure into that. But I think that is probably almost a separate discussion that goes along with the conditions that you've asked us to lay out for you. And I know for Mr. Lynch and myself, it would be more productive if you allowed us to flesh out those and present you with a list, and then take these up at the next board meeting. And I apologize, I didn't mean the next board meeting, I meant. Well, but the next board meeting is actually on the 18th when the board has their normal public meeting. I meant the next deliberation meeting.
Isn't it correct that next Thursday is the 18th?
That's correct, and that's when you have your regularly scheduled, February, that's when the February board meeting.
We are getting ready to adjourn until, no, I'm recessing again. So the Iowa Utilities Board is getting ready to recess on a HLP 2014-0001 until Friday, February 19th at 1:00 p.m. in the hearing room. We will be reconvening, however, for our monthly board meeting on Thursday, February 18th at 9:00 a.m. So the Iowa Utilities Board is hereby recessed.
I will take my stream down for today. I will not be able to come back for the 19th because, yeah, so that's my day to be at the mosque at that time, and so the Iowa Utilities Board does have its own stream, so if you can find it on their website, go to that, but the next deliberation meeting after that, March March 8th and 9th, I will be back for that. So, and thanks for watching, and I will be back live again for the Rally and Lobby Day at the Capitol, so stay tuned for that. Thanks for watching. I'll see you on the street.